Shea, and over the course of the next several of these tapes, we will cover constitutional law. Now, necessarily, we won't look in every nook and cranny, and we can't cover every case that you're covering in your course, but we'll certainly cover the main cases and the main topics, and along the way also, I'd like to highlight some areas where professors like to test you, and perhaps offer some strategies for you about how to respond. So let's start. Constitutional law can be divided into two broad categories: the powers of government and individual liberties. Indeed, for those of you who are taking constitutional law where it's offered in two parts or two courses, usually the dividing line between the two courses is just as I've mentioned, namely between powers and liberties. We'll look at powers first. Now, to begin, you need to recall that the Constitution as originally adopted without the Bill of Rights appended to it is primarily a plan of government. It creates the national or federal government with its three great departments, the executive, the legislative, and the judicial departments, and it also allocates power between the federal government and the states. That is, it carves out powers for the federal government and the proper subjects of federal powers, reserving all other powers to the states or to the people respectively, but also putting some specific limitations on what states can do in our federal system. Now, the plan of government created by the Constitution for the federal government really has two main characteristics. One is the separation and division of powers and checks and balances that is set up by that separation and division. The framers wanted a workable government, something that actually operated effectively. But by the same token, there was real worry, as I suppose there always is, about government oppression and tyranny. The framers wanted a government that was effective, but they also wanted a government that diffused power and divided power so as to prevent tyranny or oppression by any particular part. The second characteristic of our basic charter of government is federalism. Of course, the framers wanted to create a national or federal government. We wanted national unity. We wanted to behave like a single governmental body for the whole people. But at the same time, we wanted the benefits of diversity and decentralization, the benefits that you get with state and local governments. And so we've crafted a system, and the Constitution anticipates a system, that has both a federal or national government and state and local governments so that we can get the benefits of both. Now, in looking at the separation and division of powers in our scheme, frequently the way powers are thought about and the way that questions arise with respect to powers that you may encounter is what part of the government gets to take what actions. For example, as you'll see as we go on later, when we talk about powers of the president typically is the one to appoint executive branch officials. Congress may not do that under our scheme. As another example, as you'll see, if there's a conflict between federal law and state law on a particular topic, under the doctrine of supremacy of federal law established under the Constitution, federal law prevails. So if you're looking at any question of governmental action, you have to consider whether the governmental body taking the action is constitutionally authorized to do so. And that's what we're going to turn to now. We're going to start by looking first at the powers of the federal government and looking at the branches of the federal government, the courts, the Congress, and the president. Now, among the three branches of the federal government, we will start first with the power of the federal courts, what the federal courts get to do, and in particular looking at the Supreme Court of the United States. Now, why do we start with the federal courts as opposed to, let's say, Congress or the president? Well, I suppose, you have to start somewhere, so why not start with the courts? But that's not it. There really is a primary reason why we start with the courts, and almost every constitutional text starts with the federal courts in some fashion and starts with looking at Marbury versus Madison. We start with the courts because in our scheme of government, the federal courts and ultimately the Supreme Court are charged with saying what the Constitution means. The federal courts, and ultimately the Supreme Court, exercises a power that we know as the power of judicial review. Now, the power of judicial review is extraordinarily important, and it's the key to everything else that we're going to talk about. So I'm going to start first by discussing what the power of judicial review is, how it's grounded in the Constitution or in constitutional theory or interpretation, and what it actually means in terms of deciding cases. Well, what is judicial review? It is, in essence, the power of the courts to declare acts of government unconstitutional, that is, void or invalid, according to the court's interpretation of what the Constitution means and requires. This is a very, very potent power, as you know. It means that in our system, if a court declares that an act of another governmental actor is unconstitutional, then that act is invalid. It's of no force or effect. And unless the Constitution is amended, or unless in a subsequent case the court changes its mind about what it's decided, it means that the court's interpretation will prevail. And ordinary legislation cannot change things. The court is, in other words, the last word on the matter. In fact, this idea that the court is the last word on constitutional interpretation recalls one justice's famous observation about the court, where he said, "We are not final because we're infallible because we're final." And so they are. So the power of judicial review is the power of the court to say, according to the court's own interpretation, whether the acts of other governmental actors are or are not consistent with the Constitution. And if they are not, to declare them void and of no effect. And that will be the law of the land unless the court changes its mind or unless there's a constitutional amendment. Where did this mighty power come from? How was it established? Well, there is no explicit textual grant of this power in the Constitution. You could look in the provisions of the Constitution and you won't find any reference to judicial review. In addition, although there is some historical evidence that the framers anticipated judicial review, and although some state courts had exercised such a power prior to the Constitution being adopted, the evidence that the framers intended courts to exercise judicial review is certainly not conclusive. Instead, the power of judicial review was established by the court itself in the case I mentioned earlier, namely Marbury versus Madison. And there, the court decided and declared, based upon two fundamental propositions that I'm going to share with you, that yes, indeed, the federal courts do have the power of judicial review. The first fundamental proposition had to do with the nature of the Constitution itself. The court in Marbury said, first of all, that the Constitution is fundamental law. That is, it's superior to and prevails over ordinary legislation or other governmental acts. Moreover, it's a written Constitution, and it was meant to bind all actors to its requirements. So, in terms of the nature of the Constitution, it's fundamental law, superior to ordinary legislation, and binding on all other actors of the government. Now, that fundamental proposition of Marbury by itself wouldn't have been enough to establish the power of the courts to exercise judicial review as we know it. That is, we could all agree, that the Constitution controls or is superior to ordinary legislation. But there's a further question here. Who decides whether legislation, regulations, or what have you actually conflict with what the Constitution requires? Perhaps Congress or the President decides if their acts conform to the Constitution. Let's say, for example, Congress passes a law. And Congress, by passing the law, is making the determination that its law is not in conflict with the Constitution. Even though the Congress would agree that the Constitution is superior, it's written, it's binding, etc., Congress doesn't think its act was in conflict with the Constitution.